Yes, Mr. Justice.
Thank you, my lord. My lords, if we could now turn to the poster, which is in supplemental bundle tab 1, page 1, I believe, or 2. Now, there's no dispute that RD162 on the left is the lead compound being promoted by the poster and by the authors of the poster. We say that that does provide a benchmark.
Just on that, I mean, I doubt it matters, but do we take it that the use of the blue tells the reader that that is the PKDM optimized compound?
I don't think there's any evidence on that, my lord, and therefore I don't think that was canvassed below. It could well be.
It seemed to be a logical deduction from the arrows and where they stop.
It is, I accept that, a logical deduction.
Well, it's just that all the other structures are in black, and that one's in blue, and it seems, to my eyes, to be the same shade of blue as is used for the phrase PKDM optimization.
And it's at the end of the arrow that leads from the words PKDM optimization to it.
My lords, obviously it sounds entirely logical. It wasn't discussed in that way below, but it does appear to be logical. What was discussed was that anyone reading this poster would know that it is setting out what has been done in a research project on SAR and then PK optimization, ending in the lead compound of RD162. What we say, and I don't think it's disputed, one obtains from this, and my learned friend went through it briefly, but in the centre you see where they started with the enzalutamide, which is an agonist, and that's what they're trying to improve upon, and that has a dimethyl. They then work through between RD2 to RD54, following the arrow around, and show what examples of the work that had been done, and we see that various changes are made, which what's material obviously for today is the change at RD37 to a cyclobutyl at what the judge called position X, and what my learned friend relies on is the fact that that is in all other respects the same as RD7, which has the gem-dimethyl at that position, and they also show that they worked on a cyclopentyl with RD54, although the evidence was one can't make direct comparisons because that has a further change. You'll see on the right there it has a cyano group which isn't in RD7 or RD37. And I've been reminded that my Lord Justice Arnold's point was referenced in in Professor Ward's expert report in paragraph 69, where he points out that RD162 is drawn in blue font and blue text, and that seemingly marks the PKDM optimization site. So that is in paragraph 69 of Professor Ward. So my learned friend, I think he calls it a pairwise comparison, is RD7 and RD37. His case is that a skilled team reading the poster would see, or are being taught, that there is not likely to be any material difference, and he gets that, he says, from the fact that you have two compounds where the difference is the cyclobutyl and the gem-dimethyl at that position, and he says the poster teaches that they are similar in activity. I'll come to why we say that's wrong, and the judge held it was wrong in a moment, but just before we leave the poster, we then see that what was taken forward into the left-hand side, so the blue side, the pharmacokinetic and drug metabolism optimization, was a structure that has as its scaffold RD37 all the way through, but different changes or substituents are used on the right-hand side of the molecule. And you'll see RD131 has a N-methylamide linked via a propyl that's coming out of the ring. RD161 has a methylamide, and then RD162 has the fluoro and the methylamide group. And we say, and I'll show you in a moment, that what this indicates is that it is the right-hand side of the molecule which is more important for drug-like properties, so PK or DM optimization. And one gets an idea of why the changes were being made in the left-hand side, where you have one table, and below that you have a serum concentration. And what you see is that although RD37 was taken forward for its good activity, it appears to have run into some difficulties in the PK side. And so, in particular in the table, log P, that's lipophilicity, and it's too lipophilic. It doesn't have a reading for its steady state concentration, so how much gets into the blood. And in the graph below, PK of bicalutamide, and then they're testing that against 162, 131, and 37. 37 is in the light blue, and one sees that right along, bumping along the bottom of the serum concentration, indicating an extremely short half-life. So RD37 was the promising candidate in terms of activity, but improvements needed to be made in terms of pharmacokinetics, and that is what it is showing. In relation to activity, I'll come to the evidence in a moment, but there are, my learned friend touched on them, two assays on the right-hand side that matter to his pairwise comparison. The first one is headed in vivo assay, and as my learned friend explained, that is a cell line put into an animal, and then the results on fold chains of tumour volume. And both RD7 and RD37 are better than bicalutamide, but as seen there, RD37 is better than RD7 and gets better over time.
Well, how does one know if that's statistically significant?
I was about to say, it doesn't. I'm not suggesting it's statistically significant, which is why the emphasis was more on the antagonist assay at the bottom. And that shows relative PSA levels, and the evidence was that a compound that has greater activity in lowering PSA levels is more likely to be taken forward. And there the evidence was that it's the higher concentrations, the 1,000 nanomoles that are of most interest, and well, that's the light blue. And one sees just on the poster, before we get to the evidence, that RD37 is being shown in the poster as being have greater activity than RD7 by quite a considerable amount, at least on the poster. And indeed, RD37 is better than the other RD54. So of the three that one sees on the right, and including RD6, so of the compounds they investigated on the SAR study, RD37 is being shown to be the best in terms of activity for PSA reduction. And going to my Lord Justice Snowden's question earlier this morning, we say that is why, when one's reading the poster, one can understand why RD37 was taken forward. And what this poster is saying is RD37 was the most active in the most important respect, and then we've taken that forward and worked on its PK and DM optimization. So we say, just on the poster, it's not right to say that there is a pairwise comparison where the two are treated essentially equally. Now, I need to make that good now on the evidence. And my learned friend's case on this appeal is based on the evidence in chief, primarily based on the evidence in chief of Professor Westwell and his technical reasons, which he says were not challenged. And the judge set those out in the core bundle, page 51. Page 51 at paragraph 233. And the first point and the premise under which the professor worked was one of disclosure. From the disclosure in the poster, the skilled medicinal chemist would expect certain variants of RD162 to have same or similar activity and also to have therapeutic potential. In particular, he knows from the teaching of the poster that the cyclobutyl at the bottom right can be substituted with a dimethyl or a cyclopentyl, and then he refers to RD7 and RD54, without having a significant impact on in vitro activity. So he understood the poster as showing what my learned friend says as a stepwise or a step comparison, and the two are essentially the same in terms of activity. Now, having discussed the teaching on the activity of the poster, or teaching of the poster on activity, he then at 950 discusses what I would call the drug-like properties, or the right-hand side of the poster, of the compound. And so he explains that the poster then shows that to achieve serum stability, they installed a 3-fluoro substituent in the aryl ring. He then explains that that assists in metabolic stability. And then in the centre of that passage, he says, it's right in the middle, there is no reason to consider that a change from the cyclobutyl group to either a dimethyl or cyclopentyl would affect metabolic stability. So that's drug-like properties. This is because they're small changes in the same hydrocarbon functionality and are at a site that is remote from the metabolic site. He then talks about the incorporation or removal of such a group to this hydrophobic part would not significantly affect properties such as lipophilicity and solubility in vivo biodistribution in a significant way. Now, we did not attack that and those conclusions. We did not attack the fact that it would not be obvious, it would be, a skilled person would not think that any change or effect, material effect, would be made on the drug-like properties. And the reason we didn't is because, and indeed our expert said, what the poster shows you is it's the right-hand side of the molecule that matters to that, not position X. But we did attack, and we did not agree with the premise in 9.49, that activity would not be affected. So it's not right, we say, to say that it was simply accepted, his reasoning. We did not accept 9.49, which was the premise of it, and is based on his understanding of the poster. Now, in his oral evidence, he was clear that it was the PK properties he was discussing from his technical basis of a skilled medicinal chemist. And to show you that, if my lords would take the supplemental bundle, tab 11. Page 253, 253. And this is a section we'll have to come back to, but at the bottom of internal page 156, I was putting to him that he'd said that in his report that what the obvious thing to do from the poster, or indeed the slides, is to do a SAR, but then did not discuss doing a SAR at all. And I put that to him, and over at 157, internal page 157, he has an answer at line 7 where he explains that on the pharmacokinetic issue and the switch between cyclobutyl and dimethyl, I said it was a major change that relates then to the property of log P. That's minor change. Lipophilicity. He then says that an important parameter in drug design, and he knows that a switch from a cyclobutyl to a bimethyl in that position would have very minor, almost insignificant almost, change on log P. Those things can be done easily, etc., etc. So he ends that by emphasising that he's talking about lipophilicity, and then at line 18, in terms of PK properties, it would be a fair assumption to say a switch back, as I had put it, to dimethyl would have an almost insignificant effect on values like lipophilicity, biodistribution, stability, and so on. They are reasonable things to assume. Now, we are focused on activity, and on that, we need to then see what is said about that, and for that we have to go to the biologists. And the reason I say that is that everyone agreed that the assay data, and I'll show you Professor Westwell agreed it too, interpreting the assay data was not a matter for the skilled medicinal chemist, it's a matter for the biologist. Now, to make that good, if one stays in the supplemental bundle and goes to page 260, I asked Professor Westwell about the assays and the poster. And I said to him at line 6 of internal page 183, let's look at the bottom, that's the bottom assay first, the antagonist assay on hormone refractory on cancer. We know it's very important to this work. It's the title and what they're doing. We can see there that of the SAR studies, the most active...
I'm sorry, I haven't found where you...
Oh, I'm sorry, my lord. It's
183.
Page 260 of the bundle,
Yeah.
183 of the internal page, line 6.
Oh, line 6, I thought you said...
Sorry, my apologies.
Yes, thank you, I'm there now.
So I just read my question that we can see that the most active at the higher concentration is RD37.
Yeah.
He then said in the bottom right, at the highest concentration, okay, at the higher concentration. He says we're ignoring 131 here. That's because that's more active, but that's a cyclobutyl as well, and is one of the PK ones. We are just looking at the right-hand molecules, and that's the ones in the SAR. I said, yes, you see from the SAR study, 2, 6, 7, 37, 54, yes. The one that was taken forward, the most potent at the high concentration is RD37, yes. I then put to him that they've chosen to give us the tumour volume, but I say at the top, line 2 of page 184, that RD37 has the best activity. He says in line 5, yes, we could argue about the significance, and we did that earlier. I mean, on the basis of this RD37, there is a reasonable choice to take it to PK-DM optimization. And I said, it's a bit more than that, though, isn't it? What they're saying is RD37 was our best compound, and we took that forward, and then that ran into problems. On the basis of the presented information, yes. And then I say, well, the problems are all about the PK issues, and I, about line 18, say that they're trying alternatives on the right-hand side, which might suggest to the skilled reader that it's the important side of the molecule for drug-like properties, and he goes, yes, indeed. Now, we then had, that we say is important evidence, because he there is accepting actually the two are not materially the same when reading the poster. So on the disclosure of the poster, it is not right that there is a pairwise comparison and both are equally obvious. One is worse on activity. We then had over the page, on page 261 of the supplemental bundle, a discussion about my reference to the highest concentrations, so looking at the 1,000 nanomoles in the assay in the poster. And you can see at line 8 of internal page 187, he says at the highest concentrations, and then he says, well, I'm here as a medicinal chemist. I have enough to know that we should be looking at IC50s, and I won't read out all of what he says there. What I would focus on is what he says at line 21. I am cautious about interpreting what is one compound is better than another, which is why we had a discussion earlier, for example, on the RD7 and RD37, because you know these are biological systems, whether they are in vitro cells or animal models, mouse models, there's an inherent variability based on all sorts of other variables. So IC50 values will be much better, more robust discussion. You're pointing to what's happening at the highest concentration. What I'm saying is, well, that may or may not be the critical one. And I understand the complexities. It's more the field of Professor Hickson, that's the biologist. Is it not? Yes. You would agree with that? Yes. It's more for Professor Hickson. It is indeed. Yes. So he accepted that what he had said and the basis of what my learned friend relies on, which is there's no significant impact on each in vitro activity between the gem dimethyl and cyclobutyl, was his understanding from the disclosure of the poster, and we did challenge that. And not only did he accept that on the basis of the face of the poster, there is a difference and a material one, but also that actually this is a matter for the biologist and not for him.
So can I just take you back to the submission you made a few minutes ago leading into this? And I'll just read it back on the transcript. You said, everyone agreed that the assay data, I'll show you that Professor Westwell agreed to it, interpreting the assay data was no matter or was not a matter for the medicinal chemist. It's a matter for the biologist. Is that right?
Yes.
So the assay data is what's on the right-hand side of this,
and at the bottom, and that is the part of the cross-examination I just showed you.
Right, and you say that the person who should be interpreting what's on the right-hand side is the biologist.
No.
Well, that's what I've just...
Oh, I'm sorry. The data...
That's why I was confused. I'll just read to you again what you said, and everybody else can stop and read back if you want. But it was at 17 minutes past 2. Is the passage at page 8, 17 minutes past 2, page 84, lines 4 to 7? Is that what you meant to say? Because I don't think it is, unless I've just been not following. I apologise.
No, I will step back. It's my fault. My lord, if we go back to the poster...
I mean, it may just be me, but...
No, it's my fault. If we go back to the poster in supplemental page 2, tab 1...
Yes. The assays are the 3 tables on the right-hand side and the right-hand side at the bottom.
That's right.
My understanding was that you're saying the person who would interpret those tables was the medicinal chemist.
No, biologist.
Right.
Did I say medicinal chemist? If I did, that was an error.
No, I think that's what you did say.
Well, in that case, that was an error of mine.
So...
if I... Perhaps a way of seeing this...
In which case, it is me, and I apologise to everybody for going off down a rabbit hole somewhere. I'll come back on stream, if I may. Let you...
One... You can see it, perhaps set out. If my lord would go in the supplemental bundle to the evidence of Professor Hickson, so my own friend's biologist, and goes to supplemental bundle page 63. At paragraph 3.4, Professor Hickson, the biologist, explains that the biologist designs, carries out and oversees and analyses the relevant in vitro and in vivo studies and tests of drug candidate compounds identified by the medicinal chemist to ascertain whether the drug candidate compound has the desired pharmacological or therapeutic effect. They are capable of undertaking the assays and understanding the initial data, etc. And what I just showed, my lords, was that was accepted then by Professor Westwell, who accepted that although he accepted that the antagonist assay at the base of the poster that showed RD37 as the most active. He also accepted that to the extent he wasn't sure whether or not one accepts the highest concentration as the one to go with, that would be a matter for the biologists. Now that was also put to our medicinal chemist expert, and for that, if one goes to tab 13 of the supplemental bundle, page 311. What my learned friend put to Professor Ward, this is the medicinal chemist, our medicinal chemist, was his case as he's put it to my lords. So at line 7, he says...
Which page?
Sorry, page 311, internal page 383. Sorry, my lord. Yep. Line 7. So at this stage, they, and he's talking about all the compounds in the right-hand side of the poster, they would all be worth taking forward in as much as they all have potential to use for use in therapy, although of course one has to go on and consider pharmacokinetic matters. Yes? So they're all basically the same. He says, well, all the compounds are active in that assay, but they're not all identical in terms of the bars, and he's talking there of the bars of the antagonist assay. So I would want to get, I suppose, the answer to that question in terms of, well, which one would you take forward? Are they all equivalent or are they not equivalent? I would ask my biology counterpart in terms of, do these look good? Do they not look good? And then the learned friend moves on. So both medicinal chemists accepted it was a matter for the biologists, and yet my learned friend runs the whole appeal on the in-chief evidence of his medicinal chemist. The judge, of course, and I'll show you, heard the evidence of the biologist as well. Now on that, it's worth seeing what the evidence from the biologist was on that point, and while we're in the supplemental bundle, tab 12. Page 280. Of the bundle. Now this is where my learned friend put to our biologist, Professor Clark, that actually is the same point he makes today, that RD7 and RD37 are effectively the same in terms of activity. And the way he did it was, rather than seek to look at the histogram and the columns in terms of maximum concentration, he said, well, we can work out their IC50s, and that would be the way one would do it. And one sees that in line 10 of page 259, where he puts to the expert, we look at RD7 and RD37, so a dimethyl and a cyclobutyl, and if you try and eyeball the IC50,
so when he says eyeball, I take it he means infer.
He does, and what he says afterwards, we take a metaphorical ruler, and then he actually was using a real one, and we have a look at where 50% is, and we do a little bit above that, and we try and infer that the sums are similar for IC50. the expert doesn't agree with that, but what we get to at 260 line 4 is, but the point I'm making is if you try an eyeball, you would not say that the IC50 of RD37 was higher than RD7, so it, and he goes, sorry, lower, better. I think the question effectively is similar.
Can you read the answer?
And then he then goes on and at line 13, the expert says, one is looking for the greatest anti-cancer effect, potential anti-cancer effect, and a series of experiments like this with characteristics which might enable it to be given to a human without being excreted. Although we have no toxicity information here, without toxicity we might have expected. It was put to him again that IC50s are widely used, and he agreed that. But his point, and we see it over the page, was what's important here is the PSA data, which is why they have given it. And you see that over the page, little internal page 263. Line 21, what I'm suggesting to you is you say the skilled biologist would be interested in the highest concentrations. It's put to him it wasn't supported by textbooks. You are not pointing to anywhere where it's a known principle, and it's not a general way people approach this sort of data. And at 264, he did not agree. Very obvious to anybody working as a skilled biologist in prostate cancer, the PSA is important. And it's also so obvious I don't need to put that in my report. So they then discuss about its importance. And this passage ends, materially ends at the bottom of 264, with the witness saying, at line 25, you're very clear in your question. I do understand that IC50 is important, but a skilled biologist in the biology of prostate cancer and its treatment would always look at the PSA effect. And then the question PSA, but you don't attach greater weight to it. And he goes, well, I would be looking for a signal to take something forward, and if one has similar IC50 with a greater effect on PSA, that is where I would put my money.
Can you read, Andrew, can you read over here, 259?
And then at
Andrew,
yes.
Can you read, you missed it, can you just read, say, go back to it?
You can read that.
Okay.
259. Oh, sorry, I'm getting Barrett, my own friend, to take you to page 259, internal page 259, where it was put that at a lower concentration of 250 seems to be less effective. And he said, well, it's quite close. We don't have error bars, it's quite close. But as I've been showing you, his evidence has been, and I'll show you the same in a moment with Professor Hickson, that he was interested in the highest concentration, which is the 1,000, not the 250.
Okay.
And as he ended
So
at
can you
260,
give us your submission on what the upshot here is, because I'm a bit confused, because a lot of this evidence that you've just read to us is about an exercise of trying to infer an IC from a CIF50 document from IC50 values from a document that doesn't contain IC50 values. I quite understand the exercise that Mr. Turner was engaged in, which is, well, given you're not given what you're looking for, which is an IC50, you do your best with the data that you have, and you as he put it, eyeball it and see what inferences you can draw. So I understand the line of the question, and we'll have to make up our own minds as to what the effect of that is in those terms. But as I understood it, leaving aside the question of AC50 and whether you can infer that from the data, and if so, what do you get out of it, you were taking to this for a slightly different purpose, and I'm keen, therefore, that you could summarise your submission on that.
The purpose I take it for is that the expert said at the end, and his evidence was that even if you could infer IC50s were similar, you would attach greater weight to the PSA at the highest concentration, and that is where the expert would put his money. That is RD.
Okay, so let me rephrase my question in a more direct way. As I understand it, when the question is asked, do you attach greater weight to the highest concentration than the other concentrations, and the witness says, well, I would be looking for a signal to take something forward if one had a similar IC50 with a greater effect on the PSA, that's when I put my money. You're inviting us to read that as meaning yes.
Yes. And as I'll show you, that was the finding of the judge.
Okay.
And at page 289 of the bundle, little 298, he also explained there, say little internal 298, at line 11. Again, the approach is from the biologist is one's looking to see which has the greatest prostate cancer suppressive effect in the hormone resistant setting. Once hormone refractory disease happened, it happened and it progressed. One would always be looking as a translational scientist and a clinician dealing with these kinds of cases and would want to have the drug which was most effective in suppressing PSA. So what we say...
That's a statement to the obvious, isn't it? I mean,
well, maybe, my lord, but we say...
what do we get out of that?
Well, when one goes to the poster, the drug that is shown as most effective at suppressing PSA is RD37 with a cyclobutide. That's the importance of the highest concentrations, and that is why it was taken forward.
But this is why I'm interested in the highest concentration point, because as we've already seen, there's no statistics of any sort. So you have a document which on its face doesn't give you an IC50 and doesn't give you any statistics. So the question is, absent those two things, what do you get out of it? And your argument, which I perfectly well understand, is what matters is highest concentration. And I understand the logic of that. But at this stage, what you're trying to persuade us is that the evidence supports that submission. At the moment, I'm just probing as to where you find the support. And as I understand it, the key answer you rely upon is 265, and your submission is that, well, the witness didn't say yes, that was the sense of his answer.
That is right, and as I'll show you, I'll also rely on that was the findings of the judge.
Yeah. Okay.
I'll show you Professor Hickson's evidence, and for that it's supplemental tab 11, page of the supplemental bundle. Page 231. At page 66, internal page 66, at line 19, I took him to the compounds of the SAR and said to him the most potent at the highest concentration is RD37, and he says that's correct. So the molecule of the SAR testing, I'm calling it the SAR testing, of those, the one that displayed the maximum PSA reduction effect in this assay was RD37. Correct. That's bottom of page 66, line 23. Top of page 67, line 4. Now the judge made findings, and we should look at those. They are in the core bundle. page 68. Actually, we should pick it up at 67. And my learned friend skipped over this section because he said it was something they had, it was an Aunt Sally that apparently we had put forward and can be ignored. Just to show that it wasn't something that we invented, he said that it was our invention about RD7. And just to make good, I'm sorry about bundle hopping, but if one goes back to the supplemental bundle, sorry, internal page 415, which is bundle page 319. You see it, little page, internal page 415 on bundle page 319. He did run a case and put it to our medicinal chemist, starting from RD7, and you see that at line 17. Taking RD7, you could replace the methyl, etc., etc., and onwards. And moreover, he then said this morning that it made clear that that was no longer their case in closing, and that we too had accepted that it was no longer their case in closing. And it depends what you mean by their case. And he took you to where I had said, he says accepted it was no longer their case, and that is in tab 15, supplemental 391. And my learned friend took you to line 8 of internal page 699, where he said I had said he's made it very clear he's not starting from ID7. He dropped that. But I said one has to be slightly careful with that. He did say, I think, that it's academic or theoretical. What he's actually doing is he's not starting from RD7. He's trying to pick bits from RD7. We all know which bit he is picking. We say it makes no sense if activity is a concern, and I've addressed my lord that it's not a concern. But we say, and then I go back to the poster, and the reason is because, and I go on, that RD7 is worse in activity. And that had been our closing, and we have in here, we don't need to take you to it, but we have extracts of our closing submissions in this bundle in tab 17, where we set out the evidence of the biologists that actually the two are not comparable in terms of activity on the evidence of the biologists. And that was the finding of the judge. And we find that in paragraph 310 of the judgment, page 68 of the bundle. And these findings are not appealed. They're not in the grounds of appeal. In the skeleton it said they're immaterial. But these are findings of the judge below for which there is no appeal. Before he makes his findings, he sets out the evidence, and that's in 310. Firstly, that the in vivo tumour assay, that Professor Clark would be circumspect in over-interpreting that. That doesn't have error bars. But as little 2, as regards the PSA data, Professor Clark thought that RD37 was more potent than RD7, particularly at the higher concentration, and would want to take forward the compound with the best activity at the highest concentration. That was his understanding of the evidence that he had heard. Professor Hickson viewed the graphs alone without following the story and simply reviewed graphs in isolation. That goes back to some questions I had made. Professor Hickson restricted himself just to looking at the graphs. And the lack of error bars on the in vivo assay meant in that respect of that he could say no more than RD37 appears to be modestly more active. But, as the judge says in 4, he was better able to interpret the PSA level graph and he had no difficulty with error bars or such like. He puts that out in his, from his evidence in chief. And he commented on the fact that RD131 appears to have the best activity at the highest concentration, and the others were maybe equivalent depending on the concentration compared. And in cross-examination, he confirmed he agreed with Professor Clark about the importance of the best activity at the highest concentration in a prostate cancer trial. So at 311, the judge then says, overall, the experts agreed that whilst RD37 looks slightly ahead in the tumour volume, it's difficult to draw conclusions, that RD37 and 131 are both better than RD7 in the hormone refractory prostate cancer PSA level assay, something that the biologists agreed would be of real interest. He then goes on at 312 to say it was never explained why a poster at a conference would have to have error bars to make statistically sound conclusions. But the gist here is that RD37 was the best antagonist to take forward to in vivo PK testing, but its half-life and steady state then proved to be poor, and we saw the experts agreed. He then says at 314 that we had submitted that the clear take-home message of the poster was that RD37, cyclobutyl, had better activity than RD7 gemdimethyl, which is why it was taken forward into PK testing and why the structure of RD37 was used. And we say that's absolutely right from Professor Clark's evidence at T3265. He then records a case that was put to our medicinal chemist on an assumption that the skilled medicinal chemist would think all the compounds were essentially the same, and he explains it was a moving feast. He sets out all the ways it was slightly different. But at 316 he says, and this is his finding, I agree that all of this is untethered to reality. A skilled team reading the poster as a whole would understand that the message being conveyed is that the most active compounds were RD37 and RD131, both cyclobutyl, and work had been done to improve their drug-like properties, leading to RD162. And that finding, they say in their skeleton, they don't think it's correct, but it's not part of their grounds of appeal, and they say in their skeleton, it's immaterial, and you don't have to worry about it. And we say no, it is a very highly material finding on the case before you, where he talks about the pairwise comparison and there being no difference on activity. It's also highly material to the evidence of Professor Westwell in chief on activity, where he read it and said there would be no material difference, but the judge has held on the evidence of the biologists that that is wrong. And Professor Westwell accepted that it was a matter for the biologists. It also goes to the suggestion that none of this was challenged, or none of the technical reasoning was challenged. And one has to be extremely careful, as I said before lunch, in technical reasoning that goes to or teaching of the poster, which goes to activity, and technical reasoning on effect on drug-like properties. So, my lord, that then makes one turn to the hindsight part of the judgment about the other issue with the evidence of Professor Westwell, and in answer to which they are related. And the reason I say they're related is what's been submitted this morning is the only hindsight point, really, was based on the cross-examination that my learned friend showed you, and particularly the question on Pozzoli. And quite plainly, we are not standing here before this court and suggesting Pozzoli is wrong or is wrong to apply. Quite plainly, that is not our case. The judge, having heard the witness, did believe that hindsight had affected his approach. Part of that was his answer in that cross-examination, which I'll come to in a minute. But there were other reasons as well. And we say we're now really straying completely into an evaluation of the evidence, which, as has been said in many cases, this court should not readily overturn, because that is very much the preserve of the trial judge. So looking at the hindsight issue and what had concerned the judge, and he starts addressing this in the judgment at page 63 of the core bundle. My learned friend took you to this, and it starts at paragraph 285, where the judge records that it was put to Professor Westwell that he discussed steps that were obvious over the slides, but he hadn't talked about undertaking a structure-activity relationship analysis at all, so he hadn't talked about the steps that might be done. And effectively what was being put was, well, you went straight to the answer, and that suggests hindsight. And I put that to him in line 12 of the part that is set out by the judge. But it is important to see why the judge has highlighted the parts he has, because the underlining is the judge's. And at line 17, he agreed a medicinal chemist reading the poster would do a SAR, so they would try and optimise and consider alternative substituents. As the judge held elsewhere, he also agreed that is a broad umbrella term. It's not determinative what one would do. And that is the nature of medicinal chemistry. We see that in line 21. Now, 22 to 25, I asked you just to note, because the judge reinforces them later. I said to him, as we discussed, one way they would do that is because they're taking forward at RD162 when they hit problems, or they have a target given to them by the biologist, or they have another set of targets. This is the sort of context the judge later talks about. What are they doing and why? And I said, you've not discussed any of those. And his answer is important. I was asked to assess obviousness in terms of, and then he says, you could certainly do an exploratory SAR and make more wholesale changes. And then he talks it is reasonable on PK grounds, like log P, so he's now talking much broader changes. And then the part the judge underlined, I did not discuss SAR building on 162 in the expert reports, because that could be done, but it might involve more substantial changes to the substituents. Now, stopping there, that in my submission is clear hindsight, in that you are focusing, I didn't discuss what I said was an obvious thing to do, because that would involve more substantial changes to substituents than just changing the cyclobutyl at position X. So we say a clear indication to the judge hearing this, which is why he's underlined it, that all is not perhaps as it should be in this evidence. Then I said, and this is the part my own friend has honed in on, I'm assuming you were going to say in terms of the difference and assessing the difference between a gem dimethyl and a cyclobutyl. He goes, I think that was a yes. And with that change in mind, you were then saying, well, is that going to have an effect or make any obvious or not? Now that is the point that the judge held later. I accept the judge read that as a material effect. I didn't say material. But the point is not that Pozzoli is wrong, but that where one has an expert who's given evidence that something is immediately obvious, that was his phrase, on reading the poster, it is leading, or potentially leading, to have him considering whether or not at that specific change will have an effect. And moreover, when the case is being run, that this is a case that motivation isn't needed because it is an immediately obvious alternative. It matters. It's not this is not a case where the expert was asked, read the poster and tell us what you think he would do. And only after that, consider Pozzoli. So we say the judge very fairly was concerned about his approach. Certainly, we say, it is within the realms of what a trial judge could conclude. But it is not just there. The judge had more concerns. And in fact, we say he dealt with this extremely fairly. So at 288, he says that we submitted that he effectively had the target in mind, but he wasn't prepared to go there, that far. And he did not consider that was clearly established. As we see later, he did think the question was leading, and we say, fair enough, that is right. But it didn't stop there. At 289, he records that we submitted that it was infected by hindsight because, again, it goes back to a lack of any context. One starts with the agreed CGK, the start of the drug discovery project. The chemist and the biologist work together. They agree a TPP, goes back to the above. In cross-examination, he agreed that's what they would do, and what they would do would be conditioned on the TPP. And as I've shown you, the biologists are interested in the most active compound and do not share the medicinal chemist in Professor Westwell's understanding of the poster. But none of that was looked at because he went straight for the change. He also made clear that there could be considerable variation of what you do, and none of it was explored. At 290, he points to the fact that actually Professor Westwell agreed that what he said had been an obvious thing to do in the common general knowledge is a wide umbrella term, because what you do depends on how much you know, what the goal is, how much testing has been done, and so on. 291, against that background, he said, we point out that when it comes to the evidence and obviousness, there's no mention of a TPP, no mention of working with the biologist, even though it's supposed to be agreed. Furthermore, in his written evidence, Professor Westwell did not expressly mention conducting a SAR, and he quotes back to the cross-examination from which he quoted above, and part of that, 158.17 to 159.12, is the part I said was all about having a target given by the biologist. So at 292, the problem is the absence of a proper description of the context, and he comes back to that. And my learned friend said that's an error of approach, because he says the judge should not have required context. But we say absolutely not, it's absolutely right. This expert said it's immediately obvious that the two would be likely to have therapeutic potential. But then when one digs a little bit under it, one realises it's not immediately obvious. There are questions on how the biologist would look at it. There's questions of it being less potent in the assay that matters. And there's questions of what one is doing and why. None of that was explored, and the judge, and we say fairly within his remit, was not prepared to accept the evidence. But it goes on. And one sees at 294, where he points out that actually Professor Westwell actually also said that he was only considered other changes one might make, other than the only change that one knows about because of the patent, because he was asked to do. So again, it didn't arise because of a particular scenario or context, or one of these cases where one asks an expert what would be obvious to do from the poster and tries to leave that expert to answer that without being led. And then as part of being led to the answer, he also was concerned about the sequence in which Professor Westwell had the documents. And it was clear that he was shown at the slides. He was then shown the patent, and then he explained many months later he was provided with the poster. Now that's not his fault, there's obviously no criticism of Professor Westwell, but at 296 he acknowledged he was familiar with enzalutamide. So again, in these circumstances, great care needs to be taken with the instruction of the expert. He knows about enzalutamide, he knows about its structure. And then the judge, we say mildly, actually, it's curious that Professor Westwell's report was structured so he presented his views on obviousness over the poster first, even though he'd had that second, and he only used the immediately obvious wording with the poster. Now, that again is a concern on hindsight. And indeed, the judge, we actually put to him that he may have been confused or influenced by seeing the slides, and I'll show you that. He was quite open about it. If you go to the supplemental bundle tab 11, page 240 of the bundle. And at internal page 102 at line 23, I put to him the point that the judge is alluding to. So when you came to the poster, you'd already formed and given your views on the differences between the slides and the patent. That's at line 23 of page 102. And he went, yes. And then at line 19 on page 103, it's the second time I asked the question, but we can go there. At line 19, 103, I said my question was that you had formed that conclusion, and that is that it's obvious, and then you took that on when you looked at the poster. And he said, the poster reinforced those things. The poster has a different emphasis, obviously given that they are presented at the same time, but the poster reinforced my view that I had formed on the slide deck. And of course, they're not being run together. These aren't criticisms of Professor Westwell, but we say one can see why the judge had, when evaluating the evidence, was not prepared to accept it. And in addition to that, I've already shown you what he said in his oral evidence and what the biologists have said and the judge's findings. We then come to paragraph 338 of the judgment, which is on page 73 of the core bundle. And in Little Roman 1, he explains again that his problem was that Professor Westwell did not explain the scenario in which they decide to take the step, which he says is obvious. I've shown you that he uses the word scenario here, but when discussing earlier on, he used the word context. And we say he is discussing the fact that there was no appreciation in the professor's evidence of discussions with the biologist or what the biologist would be asking them to do. And in this case, if, as we say is the position, that actually on the poster the cyclobutyl is more active than the gem-dimethyl, then it requires understanding as to why the skill team would go backwards to something less active. RD162 on the poster is, if you like, the benchmark. A skill team wanting to make alternatives are not making alternatives that are worse than RD162. They don't want to do that. They want to make alternatives that are as good as or better. My own friend's case is, while they would know, because of the in-chief evidence of Professor Westwell, that they would make something as good as or better with the gem-dimethyl. We say the judge has held that is wrong. It has not been appealed. The judge had evidence to support that. And once that's gone, you're into a case where you need scenario, you need context as to why is a skilled team wanting to make one change at one place that on the face of the poster would appear to be something they don't want to do. So that's why the judge says there's no scenario, and he was right in my submission to do so, and certainly not wrong in law, in wanting context to a conclusion of obviousness. He says he doesn't explain why the skill team considers position X, nor why they start changing the cyclobutyl at that position, and one can see why in light of his findings. Little 2, he answers his answers in cross-examination. It means he's not doing what he said would be done for SAR, Instead, he was asked to consider the change and asked whether the change had material effect. And he thinks, and we say fairly, that that was leading, particularly in the context where the case is being run on this is immediately obvious, an obvious alternative, one doesn't need motive to do it, one simply, it's like a nail and a screw, or a nail and glue with two pieces of wood. He then says there's no separate body of law which is applicable if the change required to get to the prior art is said to be immaterial or trivial. These are words used in the case law, not by us. And he's right on that. And he also has not erred in law at all in saying in every case there's only one question. Is it obvious? The judge couldn't have been more accurate in our submission on the law with respect. And then whether a change is to be characterised as immaterial or trivial, or here, obviously, immediately obvious was the phrase here, is highly fact-dependent. And there's a real danger the question of immateriality is substituted for that of obviousness. Even though a conclusion that a change is immaterial or trivial will usually be determinative, in general terms I agree with Estellas' submission that these issues are not well suited in the field of medicinal chemistry, but all depends on the context. And we say there's nothing wrong with that. That is correct. And then at 4, he goes to the case what actually had then been put forward and why my learned friend is not pursuing it now, that actually the evidence was that what would happen if they did do the SAR, they would have taken them away from close analogues of RD162. So if they had done what Professor Westwell accepted was the obvious thing to do, it would take them away. And without the knowledge on the primary case, he would not have been motivated to investigate close analogues. That was a finding on the facts and has not been appealed, and he considers it later on the obvious to do a SAR case. And so he's driven to the conclusion that the change was tainted with hindsight. It's not just on that one bit of cross. There are a large array of reasons, and we say within the ambit of the trial judge to have found that way. My lords, with that, I was going to turn to the slides, and the case here is put effectively on the pharmacophore slide, and we can see that if one goes to supplemental bundle 2, page 10, also referred to as slide 8. And if it is possible to have also the judgment open, if not I will do it separately, working electronically, but the judge also set out the evidence on which my learned friend relies on this appeal on page 80 of the core bundle, para 371. Just, it's easier to see both. And the key part which my friend relies on is here Professor Westwell was discussing the slides, and in particular this slide on page 10, supplemental 10, of what's called the pharmacophore. And in 10.33, he points out that on this, the cyclobutyl of RD162, as it becomes, is designated R1, R2, and is said to have hydrophobic interactions with the androgen receptor. And he points out that therefore that tells you that this part of the molecule is involved in the hydrophobic interactions. He says the skilled chemist would want to keep R1, R2 the same in order to avoid introducing an unwanted chiral centre. It would be obvious that each could be methyl, as these would be expected to behave similarly in the cyclobutyl group, being only slightly smaller. And they are also present in RU59063. That is the starting compound you see at the top of the slide. That is the one they're trying to improve, which has with big red agonistic activity. But as before, he makes clear he's talking about pharmacokinetic properties rather than activity, because he says in the next line of 10.33, the expectation would be that substituting 2-methyl for the cyclobutyl would not materially impact pharmacokinetic properties, because they're both simply hydrocarbon groups and therefore would have a therapeutic potential and could be changed. So again, we have a similar approach, but here he is looking and using the pharmacophore in the slide for that. Now the issue here again is what is taught by the rest of the slides and what he accepted in cross-examination. Then I'll go to the finding of the judge. What is taught in the rest of the slides isn't discussed there, but if one goes back to the slides in supplemental bundle, page 10, one sees, the reader sees, that they started with 59063 with a dimethyl, and they've shown that that can be changed R1, R2 in the red. When one turns over, one sees what they did. And yet again, we have RD37 on the next slide, a potent antagonist in hormone-sensitive LN cap cells. And there you see the change. They start with bicalutamide and RU59063, both of which are agonists. And they're trying to obtain antagonistic properties. And you see on the right, they have changed to acyclobutyl. They then show the results in the relative PSA levels of RD37 and the impressive results there in activity. The next slides all teach the reader about the benefits of RD37 until almost the end. So the next on page 12, it retains its antagonism, and they have cell histograms there. Then over the page, it has no agonism, which my lords will understand one of the things they were trying to achieve is not reverting to its agonistic activity if in hormone refractory prostate cancer rather than hormone sensitive. Page 14, it shows good selectivity for the AR inhibition. In 37, it has good binding activity. Page 15, it has good binding activity. 16 slows growth, and so on. And one goes all the way through until one sees a slide where effectively the same issue arises that we saw with the poster. That's page 18. That they, and we've seen these before, they plainly had some difficulties on the PK side. Derivatives of RD37 have favourable PK that retain potent antagonism. And we see, as we saw before, RD37 having poor half-life in the left-hand graph. And then we see, as we saw before, the changes that were made to improve the PK in RD131, RD162, but no change to the cyclobutyl. And then the final conclusion side at 20, it explains they have defined a derivative as an attractive lead. That's the second bullet. Everyone agrees that's RD162. But also here, it talks about greater potency can be achieved, presumably through inducing altered AR conformation. I'll show you this is something that we didn't have in the poster, which may suggest the pocket fit is better. And unlike with the poster, as I'll show you here, it was agreed that the reference on the pharmacophore to hydrophobic interactions implies a pocket. That's on page 10. So, looking at the slide 8 alone is not the full picture. One has to look at the slides as a whole. And one sees, we say, nothing here to suggest to the skilled person at all that what they should do, and what an obvious thing to do, is to go back to the dimethyl. Now, we asked the professor about what is taught here in cross-examination, and my learned friend doesn't take you to that, but if we look in supplemental bundle, tab 11, page 250, And at page 250 in internal page 144, I put to him that there's no dispute that anyone reading this, would be the slides, would understand that RD162 is being put forward as the lead compound of interest to go forward. Yes, based on this information. Yes. And then at the bottom of the page, 922, I said, I talked about the change to cyclobutyl, and I said, well, it's that change they made which might affect the hydrophobic interaction. And so they're perhaps theorising here, are they not, that one of the benefits of the cyclobutyl is that it has induced altered AR conformation. You saw that in the last bullet point. And in my submission, his answer here is very important. He said, yes, to be clear, the major innovation is the introduction of the rigid phenyl ring. That's what's caused the switch to the agonist activity. The cyclobutyl, of course, is part of that. It has a role in binding. We've talked about whether there's a hydrophobic binding pocket and what that might look like. Yes, the take-home message, if you like, if I was reading this as a medicinal chemist, is actually in the top right. The cyclobutyl, yes, is the substituent, the R1, R2 substituent that they have chosen to base their series on. That doesn't mean you would not consider other things. It's just the basis of this evidence here is they have achieved something very significant, which is this switch in an androgen receptor antagonist, and that is pretty significant. That was brought about by two changes. I suggest the major one is the installation of the RR ring, which has then been decorated on the side with different substituents. But part of that is also to optimise the structure in the bottom left, the R1, R2. When he says optimise the structure, that is using a cyclobutyl. That is what they've done to get this benefit. And I said to him again, what they're telling us is the R1, R2 is important to hydrophobic interactions with the part of the changes they've made, cyclobutyl, achieve greater potency in the absence of greater binding affinity, inducing altered AR conformation. That's likely to be from the changes they've made to the R1, R2. The change they made was use a cyclobutyl. Yes, so you can infer that both those changes, that's the changing to a cyclobutyl and changing the arrow on the right-hand side of the molecule, are contributory. We do not know the extent, but I suggest the major structural one is the phenyl group. That's the message taken from the slide. Now, far from, again, a situation where it's just obvious that you could use dimethyl, his evidence was actually, the take-home message on the slides is they've made a significant contribution, and part of that is changing to a cyclobutyl. And again, we say, faced with that context, one would need to understand, and the judge was fair to want to understand, why is it obvious to go back and give up something that's contributing to the significant advance? Now, the judge referred to this evidence and was alive to it, and going to the judgment in core bundle, page 78. At paragraph 362, we say he very fairly set out that evidence. He thought the greatest contributor was the installation of the rigid arrow ring, but he accepted the change to cyclobutyl is part of that, as a role in binding. And you can read the rest of that quote. Then when we turn to the judge's reasons, and we see them at paragraph 380, or 379 on page 82. And my learned friend relies on the part where the judge says that the case was finally balanced, the more so in relation to the slides. He changed his mind on obviously over the slides more than once because his technical reasons were cogent, but was less clearly redolent of hindsight. But he says again, the problem is he didn't explain the context in which the skill team would make the considerations set out in his technical reasoning. So he says, well, it wouldn't make that much difference to the pharmacokinetics, but then as we've seen, which I've shown you, Nonetheless, when reading the slide as a whole, there is more going on there which wasn't discussed at all in his evidence in chief. Now he then says the claimants tried to provide a context, again with a SAR starting from RD162, and that they may well then have made, they being the skilled team, may well have made RD162 prime, enzalutamide, as a byproduct. But again, he says the problem is none of that is set out in the evidence, and there's no, we've got this large umbrella term, do a SAR, but it had failed in the poster and would fail again here, and my learned friend does not suggest the judge was wrong. Now he then discusses some points we made, and he said whilst there was a degree of exaggeration in the second, third and fourth, after the exaggeration is stripped out, there remained some force in the underlying points, and you find those a page back at 377. And we say quite right, at 377 little 2, the second point, any reader of the slides can see a deliberate decision was made to change the validity. That must be right. We then referred to the reference to the hydrophobic interactions, necessarily implying a pocket. Now, unlike on the poster, here that was accepted by Professor Westwell in his first report. And I don't need to go to it, you'll see it there in the judgment at paragraph 10.11 of Westwell 1. And the judge, and we said there's every reason to think that a larger and slightly more hydrophobic cyclobutyl could have a better fit in that pocket. And unlike the poster, this is based also on the teaching of the slides on the change in the AR conformation by the larger substituent. And he says this accords with the conclusion on the slides, which I have shown you. And at 4, a fair reading of the slides is that a cyclobutyl better fits with the hydrophobic pocket and assists in the improvement over the early dimethyl agonist. And he quotes Professor Ward there, and that is what Professor Ward explained. I don't need to go to the evidence. And on top of that, it was based on the teaching of the slides that I've shown you. So he says there's force in those, and then he goes, back in 382, with those points in mind, the skill team would be likely to regard a suggested change from cyclobutyl to dimethyl as something of a backward step. Now we say for an obviousness case, with no basis put forward for why someone makes the step, why is someone focusing on that and that alone, and why is someone doing it, the judge has held it would be thought of as a backward step. And we say it's every right then, within his remit as a trial judge, to say that is not a basis of obviousness. And indeed he goes on to say the advantage of the characterization argument, that's obvious to do a SAR analysis and characterize the molecule, was it provides a reason to ignore the fact the step might be a backward one. What he means there is that one gets RD162 prime, or enzalutamide, as he put it, as a byproduct of that analysis. But of course, he's rejected that. And he says, again, his reservations remain. It came, he said, close to succeeding, but he says if the steps required to get to the prior art to the claim are obvious, it ought to be possible to explain them in evidence in chief, and here they were not explained at all. The litigation process, much analysis on the routes to obvious obstacles in the way, and skillful cross-examination may appear to have force when in fact there's intense focus on the target. And very fairly at 384, he's not saying that obviousness can't be proved through cross-examination of a patentee's expert witness, but he cannot conclude he's received sufficient evidence to establish that on a SAR, from the slides, one would nonetheless change the cyclobutyl to a gem dimethyl. And of course he made his findings earlier on the poster, why in fact one would go further away. Here, there may be even a stronger reason for going further away, for as we've seen, the cyclobutyl is taught as being important for the interactions with the androgen receptor. And we say there's no error of law or principle or approach in the judge's finding there. He heard the evidence, he considered the issues, he didn't miss anything that he ought not have missed, and he came to an evaluative judgment. Now, I said, my lord, that the findings were not appealed, and there are 2 points we should look at, which is both the findings on the grounds of appeal and a point my Lord Justice Arnold made about a respondent's notice, because there is a respondent's notice. I'm not sure it matters, but it's important.
All right,
it's
well,
there.
thank you for drawing that to my
Yes,
attention. I'd overlooked that.
No, but
Remind me.
certainly wasn't. First of the grounds of appeal, one sees that in core tab 4. Page 220. And ground 1A is, it is said that he was wrong to look for context behind Professor Westwell's expert report, and having accepted the technical evidence on both the poster and the slides as to why it's obvious, he should have found it was. And in our submission, that is not made out. He did not accept the basis for Professor Westwell's evidence. There was further evidence which he did accept and made findings on that were contrary to that from the biologists. And in relation to the slides, he had different evidence or further evidence from Professor Westwell in cross-examination. In B, it said he failed to apply the principle the law assumes a skilled term is interested in alternative ways of achieving essentially the same result, in this case as RD 162. They do not say where he does that, and we don't accept that he does. And in C, in saying he was unable to conclude he received sufficient primary evidence, that was an error of some sort. That appears to be simply a request for this court to reevaluate. In little 2, they say he erred in the structuring his report around the Pozzoli's questions induced hindsight. I've explained to you that to my lords that the judge certainly was not saying that the Pozzoli questions are in any way inappropriate. He was saying they had been asked in an inappropriate way in the current case, but in any event, there were other reasons why he evaluated the evidence as he did. And finally, at 3, there was one where about figure 21 and a squeeze, but that has gone away and not been advanced either in the skeleton or by my learned friend. In relation to the respondent's notice, only in case it's material, if my lords turn to tab 21 of the core bundle, page 352, it's little one I'd draw your attention to. It was just because of the point that was said that we'd made no challenge to the technical reasoning of Professor Westwell, and we made clear there was no challenge that the change does not affect metabolic stability or other properties such as log-P solubility and in vivo bias distribution. But we did point out, we do say, and I have submitted to my lords, we did challenge the immediate obviousness evidence on activity and what my learned friend calls a pairwise comparison. And we say to the extent the judge suggested otherwise, this was an error, but we say it's unlikely he did so because of the rest of the judgment. For that is because he made findings that we were right, that there isn't, that the two are not comparable. Finally, my lords, we said and made, just so my lords understand also the wider picture in other jurisdictions, we said in our skeleton that there has been a finding of the German Federal Patent Court on the same prior art, that the patent is valid and the obviousness was refused, and the same we said in our skeleton that there had not been a Dutch finding, and there now has been, and the Dutch court has also upheld the patent. And in terms of how the prior art is read, if my lords just take bundle JA tab 8, and at page 284, well, I can take it from 314, page 314. This is the judgment of the Dutch court, and just on how they read the poster and the slides, you can, in the middle, about 7 lines down, there's a sentence that starts, therefore, from a technical point of view, in paragraph 5.38. It is unlikely a skilled person would have considered changes in the middle of the ring at the 5 position, that's our position X, in further developing RD162, and certainly not that they would have reverted to the dimethyl structure, which according to the presentation, that's the slides, and the poster, is inferior, particularly if RD7 and RD37, which actually differ from each other in a dimethyl and cyclobutyl, exhibit more or less similar efficacy. They would then go on to say there was no other reason to consider it, and you see over the page that they also felt that the case was hindsight driven and wrongly focus solely on the change that my learned friend suggests. They did also have the evidence of Professor Westwell. Here you see that in paragraph 5.37. The German court did not have that evidence and had different evidence, but just so you see how they also understood the prior art, that is in tab 6, page 261. And at JA 261, penultimate paragraph, the German court as well thought that the comparison of the two compounds indicates that RD37 is more active over a longer period of time, and without further deliberations regarding the significance, the skill team considers the information, they're looking at the graph, and not motivated to abandon the cyclobutyl ring that's already proven to be advantageous. And at the bottom, in summary, the assessment of all graphs relating to RD7 and RD37 in NK17. And NK17 is the poster. One gets that from page 245. Cannot provide motivation to replace cyclobutyl. And again, the case on both was rejected. And also overall, we say that what was presented this morning in our submission is a very one-sided and unfair analysis of what actually was before the judge. It's based almost entirely on evidence in chief of Professor Westwell, and I've shown you in our submission that what actually was before the court was a far wider set of evidence that supported the judge's findings, and there was no error of principle, and certainly not one which in my submission this court should overturn. And my lord, if I can help you further.
No, thank you very much.
My lord, just a few short points. Just give me a second, apologise. I was a little confused at my learned friend's submissions on IC50s, and it might just be worth taking out the prior art again, so sorry, burden report. Supplemental tab 1 poster. My lords may well have this point in mind, but obviously the two issues that my learned friend has raised. One is when you look at a PSA assay, so let's take the one at the bottom right. It's an antagonist assay on hormone refractory prostate cancer cells. Are you interested in the IC50 as a measure of relative potency, or are you interested in the highest concentration, the result at the highest concentration? My lord, the potency, as it's accepted as part of the common general knowledge, comparing compounds using IC50s, it's the same experiment. It's just if you have enough data points, you can draw a curve and find the IC50. That's a conventional, common general knowledge way of comparing activity. You don't take a single concentration, you titrate and take the IC50. And that's what the authors have done in top left. They've looked at IC50s. Then the issue which arises is there an alternative approach Professor Clark, it said, favoured this approach of looking at the highest concentration. It's not established that's part of the common general knowledge, and if it's not part of the common general knowledge, it's not a matter that is relevant for the purpose of the analysis of this prior art. You have to say, is it common general knowledge? You don't look at the IC50, you look at the highest concentration. And as my daughter would have seen, there's been no materials to support that. But more importantly, that's just by way of introduction, more importantly, Professor Ward and Professor Clark did not advance a case that you would not progress the dimethyl because it was less active than the cyclobutyl. So they did not say in the light of the poster or in the light of the slide, but in the light of the poster you would not progress the dimethyl because it was less active. That is simply not a case that was run. The point that was run was about the size of the pocket, and we dealt with that. And just to make that good, I think I probably need, my learned friend has emphasised the better evidence comes from the biologists on this, so I should take you to see how Professor Clark put it. He's in supplemental bundle tab 7, and you go to paragraph 60. He deals with this. We've looked at his evidence, I think, in the second graph. I can't remember 61, but I was going to go to 62. We're talking about the HRPC. So the third graph on the bottom right of the poster is a histogram reporting results of further antagonist assays, this time in respect of hormone-resistant prostate cancer, measuring relative PSA levels. Bicalutamide doesn't reduce PSA levels, indicating that it's not behaving as an antagonist in HRPC. The trend with RD2 and RD6 in this graph is similar to the trend observed in the first agonist assay. They're both behaving as antagonists, both HSPC and HRPC settings, in a dose-dependent manner. The rest of the RD compounds follow a similar trend. They all have better anti-androgen activity than BIC. Of the RD compounds, RD2 does show higher PSA levels compared to the rest. And that was the evidence. That was the evidence. And this point, which is pressed so powerfully today, is not supported by the biologist. And if I can then go to tab 10, just to make this good. So prior art on the poster, that starts on 222, paragraph 13. This is tab 10. This is Professor Clark in reply. In relation to the chart at the top right of the poster, that's dealing with that one, that's hormone sensitive. RD2 approximately as active as bicalutamide, and RD6 shows the better activity. I agree that RD6 shows better activity compared to bicalutamide and RD2. With RD2, it does show slightly better activity compared to bicalutamide. In relation to the chart at the middle, he then deals with that and doesn't deal with the chart at the bottom. But if I could just invite my lords to read paragraph 14, that's the middle line, that's the yellow and the blue. I think we've had a look at that. He says definitive comment is difficult at the end. So what he then goes on to do, and this was the point that was being run, is that actually when you get to the patent, you can start saying that RD162 prime is better than RD162. And this was dependent on the presence of the error bars. So if you go to paragraph 24, and you see what the witness did, there are 21A and 21B, and he takes the top of the error bar and then with a ruler draws a line and does that for all of them and says, well, how does 162 compare to 162 prime when you take the error bars? We were very critical of this because we reminded the witness that error bars are not the same as confidence limits. But there we go. And then he does it on 52 1B, and he's got colour codes and things. So he only took this point insofar it was relevant to the patent in suit. He never took it in relation to the prior art. Inter alia, no doubt, because there wasn't any error bars there in which to play this game. So, my lords, my learned friend is really attaching so much weight to this before you today, but it's entirely unsupported by either Professor Ward. We've looked at Professor Ward or Professor Clark, Professor Ward gave his 3 reasons as to why he didn't agree it was obvious, and this simply didn't feature as one of them. And it doesn't feature in the judge's judgment either. My learned friend says, well, you can read it in, but it's simply not there. We've looked at that point. So 415 of the judgment, we go to 415 of the judgment, paragraph 415. This is on the relative data in the patents, this section, figure 21 of the patents we're dealing with. And the judge at 415 says, in the end, despite his point that the skilled team would want to see IC50 data before drawing any conclusions, but acknowledging those data are not provided, Professor Hickson appeared to agree with Professor Clark that the skilled cancer biologist would be interested at this stage in the maximal blockade and would want to identify a compound that is highly active. Insofar as the maximal blockade meant the highest concentration, that's just wrong with respect to the judge, and that's why we raised it in the grounds of appeal. And I better show my lord the evidence on that, and that's just a misreading of the evidence.
What's the relevance of this? Because this is all in a different context.
Yeah, well, my lord, it's said that it was accepted that you look at the highest concentration by Professor Hickson. That's what is said by my learned friend. He points to this passage and another passage. And if I could just show my lord briefly this reference, let me take a second. It's Dato's tab 11 of the supplemental bundle. And it's page 236, the supplemental. Professor Clark, who starts at 20 on 87. Professor Clark explains that the skilled biologists are less interested in lower concentrations. The cell kill rate is inadequate and is interested in staging the maximum potency. My learned friend leverages this for both the prior art and the patent. And the witness says, I think the data as a whole is what is interesting. The comparators that are made, for example, in the patent, in the tables are IC50s. It would be more appropriate to understand the IC50 concentration as they're more rigorously tested. In this assay, what one is interested in ascertaining active is the maximum potency. You get that from 1,000 nmn. 100 and 200 are an adequate activity, are they not? I think figure 21 is probably at 50%, so it would achieve an IC50. Anyway, the witness, and one can read through to this, right through to page 96. I'm not going to do it, but the witness just doesn't accept that you go for the maximum concentration. So insofar as that matters, my learned friend says it does. That was an error by the judge and has been raised in the grounds of appeal. If we could just, let me just check this reference. I may be able to gloss over this, my lord. Just a second. Yeah, I think I've dealt with that. Tab 8.6. Yeah, I've dealt with that. We're talking about even taken at its highest. If we look to various bits of the evidence, we're talking about very, very small differences. When one looks at the poster and looks at the mouse test, we're looking at very, very small differences. My learned friend kept submitting to the court that what I was saying that the activities were the same. That was our case. Professor Westwell's case wasn't quite that. If you just go back to his expert report, and which is tab 3, supplemental bundle 9.51, which is on page 44 of the bundle. He never said, he didn't put all his eggs in the same basket. 951, he says, it would therefore be immediately obvious to the skill team that following two compounds would likely have therapeutic potential that was similar to that of RD162. And again, my learned friend pointed to paragraph 310 of the judgment. This is in this section on taking forward RD7. And my learned friend pointed to 310 Roman 4. And again, he says, look, here the judge said Professor Hickson was better able to interpret that he did not have difficulty with the error bars. He commented on the fact that the RD131 appears to have the best activity at the highest concentration, and the others were maybe equivalent depending on the concentrate compared. In cross-examination, he confirmed that he agreed with Professor Clark about the importance of the best activity at the highest concentration in prostate cancer, and it's the same point, that's the same passage of cross-examination, simply not supporting that proposition. So again, the judge doesn't actually leverage this when he gets to his analysis of inventive step. This is on the take forward RD7 argument, but insofar as that's thought to be relevant, it's not supported. Just a couple more points. If I could just go to 285 on cross-examinations. I think probably don't need to turn that up, but just my learned friend referred to a number of times that you do an SAR, and the failure of Professor Westwell to consider an SAR in his analysis. We rely, of course, on the Brugger issue. There may be many other things that are obvious. That doesn't detract from whether our primary case succeeds. And also, it was never suggested by Professor Ward that if you did an SAR, you would somehow not take this forward. That would complicate the analysis. Or Professor Ward never took that point either. Professor Ward's evidence was you'd stop. You wouldn't do an SAR. Similarly on TPP, so that's if we go back to the judgment and look at that's the point on 285. The judge does sort of occasionally move from the primary case to the secondary case, and insofar as in this cross-examination there was a reference to whether you do an exploratory SAR, that doesn't impact the primary case. It was never suggested it did. Then the TPP, that's referred to at 289. And again, my learned friend has made a new argument, and this is a completely new argument in our submission. My learned friend said that the TPP is that you're interested in activity at the highest concentration. Professor Ward, no, that's nowhere. That's not said that's part of the TPP in cross-examination. I don't think there was any cross-examination on that as part of the TPP at all. It wasn't advanced by Professor Ward in chief or in reply. It simply appeared for the first time today. The shown the poster later, that was my learned friend referred to the judge's comment that it was odd that he dealt with the poster first and it was identified later, and why did he do it immediately? And well, he was shown the poster later because it was identified as prior art. Of course, there's no obligation on the patentee to provide disclosure of relevant prior art, so that's why it's just one of those cases where that happened. And of course, it has the head-to-head comparison. It has the data for the dimethyl, and the slide doesn't have the data for the dimethyl. So that's the difference, and that's why it's immediate. we say they're both obvious, but one is immediate because it actually gives you the dimethyl data, which says, look, here it is, it works. So that's relevant. That's 297. Finally, actually, the last point, sorry. References to trivial. My learned friend said, well, I'm completely wrong when I say this is an Aunt Sally. All it is a reference to the case. I'm sorry, I just can't let that rest. I'll not sleep tonight if I do. If my lord goes to the respondent's skeleton on this appeal, have a look at paragraph 19. They're being advanced today. The appellants say that from the poster it is clear that this is a trivial change, which would make no real difference. So he's again putting our case one way in order to shut it down. Then we can see it at 26. A particular facet of the obviousness case relied on by the appellants is that some changes can be so trivial and immaterial that no motivation is required. And it's also at 68. When considering Professor Westwell's written evidence on which this appeal rests, it should be remembered that the judge rejected a case that the poster teaches that psychedelics are trivial or immaterial variants, and did so on the evidence before him. So it was more than just a reference to the case. A criticism of, well, I don't know if it was a criticism, an observation that Professor Westwell had given evidence in relation to the activity of compounds in his obviousness analysis. Sorry, that might be a bad paraphrase. But Professor Westwell says in his report, I think it's paragraphs 3 to 8 of his first report, that of course he'd read Professor Hickson before he in preparing his report. Also, I think both parties, neither of us ran a case of obviousness from the biologist. It was thought better for the court to have the obviousness case run by the medicinal chemists in this case. So both parties approached it the same way. 4 last points. My learned friend did not address the point that the cross-examination relied upon by the judge was in relation to the slides and not the poster. He just did not make that observation. In the judgment, and just to be clear, I'm not sure there's anything between us, but when the judge analyses the slides, I made this submission before, but my learned friend spent quite a while on this. The analysis, we say, is paragraphs 379 and 380, that's the primary case. Everything which follows is about the SAR. And that's why that's the secondary case which we dealt with briefly at trial and which we're not pursuing today. And if you go to 383, that's self-evidently the case, the characterization argument, and then that's why the judge said, well, you never put it in your evidence in chief. I'm not saying you can't develop a case for cross-examination, but you don't succeed in this case. My Lord, one further point on this relative activity of compounds. Let us assume that the poster disclosed that, or taught one way or another, that RD162 prime was likely to be 15% less active than RD162. So just let's assume that.
Sorry, I didn't. How can we possibly make that assumption?
Well, let me just take the poster out. So let's assume that you look at these. You look at RD7, let's say, and you look at RD37. You do the comparator, and you say, actually, I think RD37 with the cyclobutyl, you're going to be a bit more active. Let's just assume. Interpret that data. Let's assume you say, well, I think on RD37 is the cyclobutyl is a bit more active than the dimethyl. And I throw out the figure 15% as a suggestion. The compounds are still undisputably much more active than the standard of care at the priority date. Now, in practice, in those circumstances, it may be that you, for commercial reasons, you don't want to produce a product that is, for commercial competitive reasons, that is slightly less active. But it's still obvious that it can be used in accordance with the claim of the patent. So it still falls within the claim of the patent. And you still self-evident what it is. You know what the structure is. You know what its activity is. You're not talking about embarking on a line of research. So you say, well, RD7 is, with the dimethyl is very active. It's much better than bicalutamide. Okay, it's a shade worse than the cyclobutyl, but it's still obvious, and it still falls within the claims, and it's still that's sufficient. Other things are commercial matters. So, my lord, that is our sort of backup answer to that. I'm not trying to detract from all the other submissions I've been making. And finally, this is the final point. The German and Dutch decisions, they're subject to appeal. They haven't been to appeal yet. Of course, they have very different, well, they had different evidence. I'm saying very different. They had different evidence, we say they can't really be of any assistance on this analysis of whether this appeal should be allowed or not. My lord, unless there are any further questions.
No, thank you very much. Thank you both for your submissions and those behind you. We've done a lot of work, we know. We will be reserving our judgments. They will be handed down in the usual way, that is to say, in draft for purposes of correcting typographical errors and obvious mistakes of that kind, not to re-argue the case. And also for the purpose of enabling you, hopefully at that stage, to agree a consequential order. And if you can't agree a consequential order, brief written submissions, please, and we will deal with it on paper. No further attendance will be required. At that stage, as you all know, the drafts are confidential under embargo, and the embargo must be strictly observed. We are, of course, conscious of the commercial interests at stake in this case, and we will endeavour to be as fast as we can. But I'm sure the parties will appreciate that this time of year, many parties are wanting the attention of the court. And therefore, I'm afraid to say we can't make any promises about when the judgments will be handed down, but it will be as soon as we can achieve.